Welcome to Florida is Our Domain.
Hello and welcome back to Florida is Our Domain with Anthony Policastro. Anthony is a Florida eminent domain attorney and the founder of Policastro Law Group. With over 30 years of experience in the field, he represents national corporations, business owners, and individual landowners across the state. My name is Kevin Rosenquist, and in today's episode, we're walking through the typical timeline of an eminent domain case in Florida, from the early warning signs to resolution, so you can better understand what to expect. Tony, welcome back. It's great to see you.
Good to see you again, Kevin.
So when a property owner first hears that a public project might affect their land, what's happening on the government side at that point?
What's happening is that the government goes through a number of steps over years, really, to bring a project forward. So they're going to start with looking at, or they should start at looking at various alternatives. Usually there's 3 different alternatives, plus a no build, which is really doing nothing. They analyze what we call scale, safety, costs, alternatives, long-range planning, and environmental. And then the next steps, of course, are they have construction plans, and they can have construction plans at 30%, 60%, then 90%, and 100%. But they normally start moving forward when they have 60% plans. They also, during the course of developing their, or rather, after they have their PD&E done, they have a number of public meetings and hearings and get input from the public, which can be property owners and businesses directly affected, or just the surrounding community or neighborhood.
Okay. And what is the first official step a government agency takes to start an eminent domain case?
Well, officially how they start is they have a resolution of necessity. And usually a resolution of necessity, if it is the DOT, it's signed by the district secretary who has the power to do so. If it is a county or a city, it is a board, and the board, such as in a county board of county commissioners or city council, they would vote and approve that project, and they would move forward with then the resolution of necessity, which is then followed up by a notice to owner to begin the project. And that's when they go ahead and they start sending out their appraisers to appraise the properties, do site inspections, and then they make the property owner an offer.
Okay. And what should a property owner do early to protect themselves if they think that their land might be taken? They hear about a project and they think it might be something that could affect them. What should they do?
Well, the first thing they really should do is they should hire an eminent domain attorney. And that would be somebody who practices solely in the area of eminent domain, like I do. They don't have, various practices. What they used to say or still say is, a jack of all trades, a master of none. So you want to get somebody who is a master at eminent domain. I've been doing it for 33 years. So you want somebody like that who can also hire the right experts for you that are well-versed in eminent domain and that they've all experienced going through litigation and jury trials. So that would be important. And it's important to hire somebody immediately or as soon as possible, because it doesn't cost the property owner or business owner anything to have good expert advice up front as the project develops. And I know here at Policastro Law Group, we keep the clients fully informed. We update them with update status letters at least twice a year, sometimes quarterly, depending on how close the project is to coming to fruition.
So are there other advantages to doing it like right away versus waiting until, till further along in the process?
Well, some of the things that are good to get a grip on right away is issues such as, if you have a mortgage, having the attorney look at the mortgage to see the eminent domain clause or condemnation clause in the mortgage, which will usually be there, and it will usually state either the lender gets all of your eminent domain proceedings or they get a certain percentage or portion of those. And I think that's good for the property owner to know up front, because the lender sometimes will take some of that money and then of course they'll apply it directly to the homeowners or business owners principal. Also, what's important is to review the leases. Sometimes the owner will have a lease with the business tenant that doesn't address condemnation. And if it doesn't address condemnation, believe it or not, the business owner could get a percentage of the property owner's award, separate and above a business damage award, if the lease is silent on that. Sometimes it is important also if it is a owner of the property, and this is very important, if it's the owner of the property who also operates a business on site. Often these business-owned property owners, they do not necessarily have a lease in place. And if you don't have a lease in place, according to the law, you're a tenant at will, even if you're the owner of the property and you're the owner of the business. If you have a different business entity from how your property is held, then you do need a lease in place. And so we do help our clients put together a lease to make sure that they can make a business damage claim greater than 30 days, because you'd be considered a tenant at will if you don't have a lease, even if it's the same people. So for instance, often a husband and a wife own the property individually, but the business is owned in a corporate entity. And if there isn't a lease in place, then business damages are cut off after 30 days, which is really would be a negligible amount of money. So you need to have a strong written lease in place. Usually you want to have a lease in place that also creates options. So typically, we're creating leases that are 5-year leases with, say, 4 or 5-year options for the property owner. And that's only fair because you want to have that, because you're running the business, you've been there for years. So you can imagine if you're on site working your business for 20 years and the DOT comes along and takes 50% of your parking. Well, you don't want to just be paid business damages for the loss of 50% of your property, parking rather, for 1 month.
Mm-hmm. So can you explain the initial appraisal process? We've talked about numbers and all that. How does the government's, how do they develop their offer?
All right, so they go out and they have a site inspection. And when they're there on their site inspection, I'm always present at the site inspection. I think that's really important. You don't want the government to be out there with their experts, and usually people from their office as well. Sometimes it can seem like a little army has landed on your property, because they will have outside appraiser, outside engineers, outside land planners, outside fixtures appraisers, outside contractors. Then in-house, they'll have their own review appraisers. They'll have their acquisition agents. They will have so many people out there, and they'll be just milling about your property. And you want to be there to sort of help your property owner, right? Make sure that they're not asked, a bunch of questions and wind up being quoted or having whatever they said misconstrued in an appraisal report. And so you want to be there and just watch what the other side, the government, is doing, and make sure that they if they want to ask questions of the property owner, as I always say, put those questions in writing, and then we'll answer those questions back in writing, so there'll be no misconstruing of what the answer was.
Okay. And then, so what happens after that first offer? Do a lot of people accept it?
Well, and just to back up a little bit, Kevin, what happens is after they have that initial site inspection, then it takes whoever is doing the appraisal for the government side. It usually takes them a few months to develop their appraisal report. They put it into some draft form, and then they send it in for the governmental entity to review it. And that review process can take up to 30 days or more. So often, the minimum amount of time is usually 3 or 4 months after the site inspection that you'll get an offer. Sometimes it's 6 months, and I've already had clients that have waited for over a year from the initial site inspection before they receive an offer. Then they receive that offer. With the offer, they usually receive a letter that says something to the effect is you need to respond in 30 days. Well, you don't need to respond in 30 days. But that really can be misleading for property owners. You're right. And that's why property owners that don't have an attorney at that time sometimes panic, and they'll either accept that offer or they will negotiate for very little more. The best thing to do, of course, is once you have that offer in hand, if you haven't gotten an attorney, you should get an attorney at that point. But hopefully you've already done so before the site inspection. And then the attorney will have a team assembled, and that attorney will take a look at that appraisal report with their experts and take a look to see what flaws might be in that or certain things that weren't accounted for. And I like to work closely with my client, have them, of course, read the DOT appraisal report and their other reports. And then usually we all get together, the client and the experts and myself, go over that report, discuss it, make sure the owner understands the position of the governmental side of it, but then also understands how we'll develop the case. And we usually have a good discussion. And then we begin to put our reports together. And then from there, I always have the property owner essentially review all those reports. And if they're happy, then we go ahead and send those reports on over to the other side. And that's a counter offer. But to answer your question directly, no, you don't have to accept it. And you do have time to formulate your own counter offer to the government.
Good. That's a good piece of information for people out there. Would you say that that part of the timeline is the one that probably surprises property owners the most?
Yes, they think that they're going to be getting an offer within days of the site inspection, and that doesn't happen. It takes some time to do that. And also they have to realize, and they do, that it's going to take a little time on our side of things. It depends on how many experts we have too. So if we have an engineer and appraiser, it's just an engineer going first, and then that report is given to the appraiser, and then the appraiser can do their report. But if you've got land planning involved, you've got contractors involved, you've got fixtures appraisers involved, it all builds like a pyramid on top of each other. And all of those supplemental reports go to the appraiser, who then takes all those reports and uses it to create his or her appraisal report.
All right. And as you talked about the how the timeline can vary as far as when you get that offer from 30 days, months, year, even longer sometimes. This is probably case dependent, I know, but as a general rule, is there kind of an idea of how long one of these cases typically takes from start to finish?
Again, that's tough. It depends on what the property owner or the business owner wants to do. With the property owner, usually, it depends on if they want to negotiate pre-suit or they want to wait till a lawsuit is filed. Sometimes it's good to try to settle the case pre-suit, depending on the circumstances. And other times it's better to wait until a lawsuit is filed and the property is actually taken, and you do a mediation thereafter. So what I normally like to say is once a lawsuit's filed, that we will go ahead and mediate or try the case, do a trial, a jury trial within the first year that the lawsuit's been initiated by the condemning authority. As far as the timing of the lawsuit after that offer, again, that depends. Per law, they have to wait 30 days, the government, before they can file a lawsuit after they've made the initial offer. Then they can file a lawsuit to condemn the property. Usually, it takes them at least 3 to 4 months after they file the lawsuit to get into court, to get in front of the judge, And again, they have to show necessity to take someone's property, and that they have to show a good faith appraisal in order to condemn someone's property. And this is important, is that when they condemn the property, they have to take what they think the property is worth, their appraisal amount. They deposit into the court registry 20 days from when the judge signs that order. And that allows them to actually take title to the property, even though that case is not settled yet. It's called a quick taking in eminent domain, and it allows the government to basically take all the properties they need before they've settled with everybody, so they can begin road construction if it's a road project, or if it's another public purpose project, same thing.
How often do these cases actually go to trial? Is it a large percentage?
No, it's a fairly small percentage. Usually I would say it's less than 5% of cases today wind up going to jury trial. Most cases settle through negotiation or mediation. However, again, I think it's very important to have an attorney represent you that does have jury trial experience. I do have that. And many other eminent domain attorneys, unfortunately, do not have either any trial experience, or they've only done 1 or 2 trials. I know that I've done over 10 jury trials.
Mm-hmm. So, and for anyone who's unaware, who might be listening to us, can you describe the mediation process?
Well, the mediation process, it is a good process. Both sides will agree on a mediator. Usually the mediators that are chosen are experienced eminent domain attorneys themselves. They've either worked on the government side, they've worked on the property owner side, or they've worked on both sides. And they will go to the mediation. They are a neutral party. They're essentially appointed by the judge. They are the judge's representative at the mediation. They try to facilitate a settlement and bring the parties together. How that occurs is both sides will get together in a conference room and do opening statements. Usually the government will go first, and then the property owner or business owner will go second. After everyone's got an opportunity to speak, the mediator will break the parties up to separate caucus rooms, in separate conference rooms. And he or she will try to go back and forth with various counteroffers throughout the day and try to get cases settled. I always tell my clients, be prepared to stay there the entirety of the day. Normally mediations begin at either 9 or 10 o'clock in the morning. They normally go after 5 o'clock. I've had mediations go to midnight. So it can take a long time to try to get a settlement. In general, I would say my experience is going back and forth in counteroffers and offer rounds. It usually takes 8 to 12 rounds at least to settle a case.
Wow, 8 to 12.
Yeah. And
a lot of negotiation.
It's important to note the mediator has no power to settle the case. He's not an arbiter. He is just somebody who's there to just try to facilitate the settlement.
Good point to make clear. Yeah, they're not. They're just sort of, they're mediating. I mean, let's be honest. They're mediating the conversations, but they're not ruling.
Correct.
Yeah,
you got it exactly.
Wow. Well, interesting stuff. That's quite the process. And thank you for going over that with us. And thank you for listening to Florida is Our Domain. If your property is at risk or you've already received notice, it's important to act quickly and understand your rights. To schedule a consultation or learn more about the eminent domain timeline, visit www.policastrolaw.com to connect with Anthony. And don't forget to subscribe to our channel. Leave us a review. We very much appreciate it. Tony, always great chatting with you. Thanks so much for your time.
Thank you again, Kevin, as always.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.